Good afternoon, Your Honors. May it please the Court, Will Holloway of the Williamson County Bar, on behalf of the husband, appellant Brandon Hurst, if I could reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
Thank you, Your Honor. Your Honors, this case, this appeal stems from a divorce case in Williamson County. The appeal from husband's perspective really concerns the classification of two assets that were a part of this trial. The first asset was referred to at trial and also in the briefs as the farm. Is a farm located in Williamson County. The trial court determined that the farm was wife's separate property at the trial. That determination is challenged by husband on appeal. Husband presents two alternative arguments on this asset. The first argument husband submits is that the farm, the equity in the farm, was commingled during the marriage such that the entirety of the asset should be treated as marital property. Alternatively, if this court disagrees with that argument, then husband would submit that due to both parties' substantial contributions to the preservation and appreciation of the asset, that the appreciation during the marriage should be classified as marital property. If I could briefly provide a little bit of background, the parties, they started dating in 2016. It was undisputed that at that time and at the time of the marriage, wife owned the farm. Husband and wife dated. At the time, husband was working for a local camp, providing maintenance work and work dealing with the horses. Wife described to husband issues she had with regards to maintaining the farm. She was recently divorced from a prior relationship. Her husband was the breadwinner and was providing financial assistance so as to allow her to keep this horse farm going, and explained to my client that she was having trouble with it. My client and wife began dating. He started to help at the farm. In the fall of 2016, he moves on to the farm with wife. Now, still unmarried at this point. Moves on to the farm with wife and continues to work on the farm to the point that he was working full-time. He quits his job at the local Camp Marymount, and takes on a full-time role at the farm. In 2018, husband has a severe accident on the farm. He's riding a tractor down a large hill. The brakes fail, and husband continues down the tractor, is forced to jump off of it, breaks both of his legs, has serious back injury, serious problems there. So then, September 2018, as he's continuing to rehab, the parties get married. At that point, they'd been working together on this farm for approximately a year and a half, and so they come into the marriage with that type of working relationship. The argument about commingling, I concede, really can't take into account what happened before 2018 and the parties' marriage. So the parties get married September 2018. And there's an email from wife in October 2018, just right after the marriage, where wife kind of describes what she wants to do. And she talks about this partnership and working together to generate this business partnership, as she used it, meaning, or as she described it at trial, meaning a marital partnership as opposed to any type of legal argument or partnership, but she wanted to work together to generate this. And what happens from that point, and really this talks about the commingling argument, is that wife, utilizing a company called the Green Barn LLC, provided horse boarding services on the farm. There was a DBA also within the Green Barn that was called No Worries Pet Sitting that provided some pet sitting services as well. So beginning September 2018, both of the parties are working on the farm through the Green Barn, generating revenue for the company.
Was husband getting paid at this point in time?
Yes, Your Honor. Now, paid, I would use that term loosely. What wife described is, starting back in 2016, wife said husband's compensation was going to be $800 a month. But importantly, that $800 a month never is actually paid to husband. It remained in the Green Barn's operating account. And so what we have is wife's income deposited in the Green Barn operating account, husband's income deposited in the Green Barn operating account. That operating account pays all of the business expenses, some of the personal expenses, and then wife would transfer money into her personal account.
Wasn't the husband, some of husband's debts or insurance or something like that being paid?
His debts from the Green Barnes account, I'm not.
I may have that confused, but I seem to recall from the briefs that there were payments being made on behalf of husband. Perhaps it was for insurance or insurance on vehicles or.
I think it's fair to say that all of the household expenses, or at least practically all, in the record were being paid through that Green Barn account.
But he had a designated amount of money that was called his salary. Is that accurate?
$800 a month.
Okay.
But it remained in that account. And so from that account, wife paid the mortgage and the property taxes and the insurance, all with that combination of her income and his income. And that's the commingling argument in a nutshell. There was clearly marital property that was earned through the parties' labor that was deposited into these two different accounts and was used over the entirety of the marriage up to their separation in January 2023 to pay the property taxes, the insurance, all of the expenses of the household.
But wasn't the husband conducting other business at this point in time as well?
At a certain point, husband starts the Franklin Towing Company. That money would not have been deposited, at least not directly, into.
But he was doing other things as well.
Right. And that is one of the factual findings the trial court makes that we raised an issue with. The trial court says that when husband started Franklin Towing, he stopped contributing as much labor to the farm. Respectfully submit, there is zero evidence in the record to support that finding. The only evidence in the record was with regard to to Franklin Towing, was with regard to husband explaining that the reason the towing company was so appealing to him was because it allowed him to prioritize the farm work. And then at night, when he was done working at the farm, he could pick up a towing job every once in a while.
Well, didn't the husband find, or didn't the trial court find that husband was contributing minimal labor to the farm anyway?
I don't recall the trial court saying minimal labor.
My words, not the trial court.
Okay. The trial court, at one part of the order, the trial court says husband's labor at the farm increased over time. At one part of the trial court's findings, it finds credibility issues with husband with regards to what it called evasive testimony. But at other parts of the memorandum, it cites to a lot of husband's testimony with regards to his work at the farm. And I understand how this court views credibility findings, and the trial court being who gets to see the witness. And so what we submitted in the reply brief really breaks down just wife's testimony on this issue and on husband's substantial contributions to the farm. And even if one simply looks at wife's testimony, I submit the substantial contributions to the preservation and appreciation are there for both parties. But the trial court's memorandum does make those findings, but then also makes findings that are directly tied into husband's testimony. Briefly, if I could, on the substantial contributions argument. And so that the commingling argument is simply related to the financial relationship and how the marital income was tied into the equity in the farm. The substantial contributions argument, I respectfully submit that the financial impact or arrangement that the parties had is still relevant to the substantial contributions analysis. In other words, contributing marital property, whether it be husband's income or wife's income, to the farm to pay the mortgage, the property taxes, and insurance, that is a substantial contribution to the preservation and appreciation. So that financial relationship really ties in with both arguments on appeal. In addition to that, I believe the substantial contribution argument really goes a step further and looks at what did the parties do on the farm. And we laid out a lengthy list of all of the proof that was introduced at trial with regards to the work that was done on the farm by both of the parties. In our brief, we cited to the Humphreys case. Humphreys case was a case out of this court in 2001. I respectfully submit it's very similar to this case. It was a short-term marriage. Husband owned a business that had limited success before the marriage. Both parties After the marriage, started working at the business. Wife was responsible for interior design work of the business, and husband continued to run the business as he had before. That's the same as here. The trial court in that case said that when you both work for the business, you both made a substantial contribution to its preservation and appreciation. The husband challenged that on appeal. This court called husband's challenge without merit. I respectfully submit the facts in this case are the same. Wife acknowledged and testified that but for the work through the green barn, she would not own the farm. She would not have owned it at the time of trial. Husband contributed his full amount of his salary, the $800 a month, every month to allow the parties to continue to own the farm. But even then, and this is wife's testimony, not husband's, not just husband's, I should say, even then it wasn't enough. And wife would ask husband for more money. And husband would restore motorcycles and vehicles, he testified to this, and would contribute. And wife said he paid whatever she asked him to pay. And so husband made substantial direct contributions to the preservation and appreciation of the farm. The final or second part of our appeal concerns a 2009 Dodge Viper. This was an asset that husband acquired through the sale of really three different separate property assets. We provided a tracing in the trial for this and also tried to lay out that tracing for this court on the appeal. We submit that that asset clearly was husband's separate property. The trial court disagreed, finding it to be marital property. And so our second argument on the appeal is asking the court to reverse that finding as well and remand this case with instructions to the trial court to number one, treat the farm as marital property, treat the Viper as husband's separate property, and then to value the assets as well, because under the current memorandum, we don't have trial court values. Thank you, Your Honor.
Thank you. Pardon me, what was the monthly mortgage payment on the farm going 2018 forward?
I don't know, and I don't want to guess, Your Honor. I'll look in my brief in the memorandum to see if I can find that.
All right.
It changed during the marriage, but I'm not sure on the specific.
All right.
Good afternoon.
Good
My name
afternoon.
is Joni Abernathy of the Franklin Williamson County Bar, and I represent the wife. To answer Your Honor's question, I believe the record will reflect that the mortgage payment was between $2,100 and $2,200 a month.
Okay.
This court should affirm what Judge Woodruff ruled regarding the classification of the farm as wife's separate property, and that there had been no commingling. My review of the record, as I hope Your Honors, will reveal there is no other evidence that preponderates otherwise. There was a list in the technical record contained in the judge's memorandum ruling that indicates what facts the court relied on in finding its conclusion that the farm remained separate and not commingled. One of those was that the parties came into the marriage with the idea to keep everything separate. And they did keep everything separate. Even husband's business, which was the Franklin Towing that Your Honors asked about, that he started in June, I believe it was, of 2020. He had a home before marriage that he had received from his grandmother. He sold that home in May of 2020, a year and a half, 2 years into the marriage, and he got $139,000. He kept that money separate. He put it in a bank account in his name only. He started his business, Franklin Towing, did not put Jeffri Hurst's name on there as a co-owner of that business. So the evidence indicates exactly what Judge Woodruff found, that wife intended to keep her separate, husband intended to keep his property separate. Wife did not make a claim at trial that she had any ownership interest in Franklin Towing. She acknowledged he had started it with separate money. I dispute that Humphreys is akin to this case because in Humphreys versus Humphreys, the non-owner spouse invested pretty sizable amounts of money. I think the court found in that case one amount was $30,000. In our case, Hurst versus Hurst, Judge Woodruff specifically found that husband admitted he made no financial contribution to this property as one of his findings to support his ruling. In Humphreys, the wife also made other contributions other than the initial $30,000. I believe it was $30,000. So I do think it is distinguishable and potentially more in line with Francis versus Lewis, which also was cited in my brief as coming out of the Court of Appeals. And in that court, the trial court had awarded a husband $250,000 as an award of part of the increase in value of separate property. The Court of Appeals for the middle section reversed that ruling, finding that he had not made real and substantial contributions, nor had there been any commingling, as I suggest the case is here. I would suggest to this honorable court that if the Dodge Viper should have been classified as husband's separate property, that error is harmless error. When Your Honor looks at the Rule 7 appendix, the next to the last page, I believe it is a summation of the property husband received. It shows on there he received marital property in the amount of $91,568. That includes the Viper that he valued at $70,000. It also states that husband's debt is $63,000. That includes a $19,000 debt against the Viper. Even if we take that $70,000 asset and move it to husband's separate property column, and we move the Viper's $19,000 debt to his separate column, he still is ahead of wife. Because if you look at the next page, which is a summary of wife's marital assets and wife's debt, she's upside down $116,500 in her division of marital assets and marital debt. The judge had found that there was debt at the time of marriage to the tune of $450,000, being the lien for a mortgage as well as some tax debt she owed, but that during the marriage, the debt increased, and that wife at the time of trial owed roughly $670,000 that consisted of 2 new loans that were farm-related of $100-ish each, as well as some tax debt. So even though the property value increased during the marriage, $739,000, so did wife's debt increase to the tune of over $240,000. That's debt in purely her name. If Your Honors please, we also requested that the court should remand for attorney fees, that it was error not to award wife her fees. And I base that in part on a review of the record. Husband's response and reply brief indicates that one of the very first hearings in this case, in March of 2023, was a motion for husband to be awarded exclusive possession. And he states that he won that issue, so that should affect the court's ruling on wife's attorney fees. But if you review the motion filed by husband in the technical record, the response filed by wife, and the court's order, Your Honors will see that the judge ruled the husband is allowed to remain on, well, first it says, husband's motion is not well taken in part. Husband is allowed to remain living in the home on wife's separate property, conditioned upon the following: as long as he pays $2,500 rent, as long as he complies with the zoning regulations regarding his storage vehicles, and as long as he complies with the terms of the Chancery Court's temporary restraining order that the leasee of the property had obtained against him from harassing, intimidating, and infringing on her enjoying peaceful possession of the property she was leasing from Ms. Hurst. Then if you look at Trial Exhibit 26, I think it is, wife's attorney fee affidavit, you'll see that month alone, wife's attorney fees were $14,000, the most of any month they had been that throughout my representation of her, because of that exclusive possession. And your honors probably already know this, but guess what husband did? Immediately upon the court ruling, he had to pay $2,500 to stay on that in the house. He vacated. He gave notice to vacate. And the court's memorandum ruling even makes a finding that when he vacated, April 23rd, 2023, he left the property in disarray and damage, meaning damage to drywall, damage to a garage door opener, and debris and trash throughout the property. And as of the trial, had not even reimbursed her, quote unquote, was the finding made by the trial judge. The husband also cites, and his lawyer just told you, that he believes there is zero evidence to support the court's finding that the husband devoted his time and effort to Franklin Towing. Well, here's what the record will reveal when you review it. The record will reveal that the judge found the husband was not able to physically contribute between the time of marriage, September 2018, and November 2019, because he was under a doctor's care for his injury. And then here's the important part. The judge found that husband devoted his time and attention to Franklin Towing after June of 2020. A review of Exhibit 16, which is collection of husband's tax returns for 2018 through 22, proved the judge's point, but also husband's testimony. Husband acknowledged that his tax return Schedule C for Franklin Towing in 2021, the first full year of business after he started it, he grossed $117,000, and the next year, $136,000. The court's memorandum ruling even states that husband grossed $10,000 a month. That's a lot of towing vehicles. So I respectfully disagree with counsel for husband that there is zero evidence in the record. Everything that the court found is clearly in the record, and the preponderance of the evidence supports his ruling rather than not support the ruling. Back to the attorney fee issue for just one moment. At the trial, husband testified he wanted the Viper and that he was willing to pay the Viper debt, the $19,560 debt that he said was obtained for the purpose of him buying a flatbed truck for Franklin Towing, and that he could get a better interest rate if they used wife's credit as opposed to his, so the loan was in the name of wife, but secured by this Viper. At trial, he said he was willing to take the debt and get it out of wife's name. He just hadn't done it yet and was waiting for the trial to be over. The ruling comes down in the judge's memorandum ruling, and it is not clear where this debt goes or who pays it. When your honors review the motion, Rule 59 motion filed by wife, that asked the court to clarify the $19,000 debt, and when the court reviews husband's response to that, where he says, Well, the memorandum order states that the parties each incurred debt during the marriage for his or her personal use, and they should pay their respective debt. I didn't think that was clear, because he's the one that incurred it to buy his flatbed truck for his business. It just was in her name, and he even testified he was the one to take it. But in his response, he made us have to fight that issue, and the court ultimately ended up ruling that debt goes with him and with the Viper. So wife has had to incur attorney fees to defend the property that was her separate property, to pursue an equitable division of what marital assets there were, and to obtain a satisfactory ruling regarding the allocation of that debt, but also regarding the $9,500 in cash that you'll read about in the transcripts and the memorandum ruling. The wife had bought a car from husband, had a wreck. The insurance company paid her. She handed the cash to husband and said, "See if you can find me a good car." Husband had not been able to find a car by January, the month of separation, January of 2023. So the text message exchange between the parties that was offered into evidence, husband said, "I'll keep the money in the safe. It will be safe." And come trial, that money was nowhere to be found. The memorandum order found that the wife owned that $9,500, but it didn't specifically order husband to pay it. We had to file a Rule 59 motion to ask the court to clarify, did husband owe that? Husband made us have to go argue that issue, and in fact, the judge did affirm the motion and grant her the judgment for the $9,500. So at every turn, she has had to fight husband on the issues for which she should not have had to fight. The record will also show in her testimony, I think it's page 178 of volume 7, that she used separate inherited property to the tune of $80,000 before marriage to pay her legal fees. And that is one of the subparts of Factor 13 in 36-4-121, where the court is to look to see how marital assets and debts are divided as to whether those attorney fees were paid with separate property or marital. I am so sorry, I'm out of time. Does the court have any questions? Thank you kindly.
Thank you.
Thank you, Your Honors. Just very briefly, the argument of kept everything separate. Their incomes were not kept separate. That was undisputed, and they were kept in those two accounts I referenced before. But the argument is really one that talks about the intent of the parties. Well, the parties intended to keep things separate, and they filed separate tax returns. And that's really what the trial court's memorandum focuses on as well. That analysis is about transmutation. There's 4 factors this court has outlined that a trial court's to analyze for a transmutation. And the trial court's memorandum analyzes it under those 4 factors. This appeal's about commingling. Intent as to whether you meant to commingle is irrelevant to that analysis. The question is, did the marital and separate property become inextricably intertwined to the point that you can't back it back out? And at no point did I hear or see in a brief from wife, can she articulate what portion of the equity in this marital residence, or stated a better way, what portion of her bank account went to pay that mortgage every month that was separate property versus marital? It was a combination.
Looking at the record, what will we find about what your client contributed to the mortgage? Earlier, I understood you were saying well, he didn't get his $800 a month, but he was not entitled to $800 a month if he's not working, and he didn't work from sometime in 2018 through 2019 because of his injuries.
I don't believe the court will find that in the record. Husband's testimony with regards to his injury is that the injury happened in April of 2018. The parties get married September 2018. He was, by that point, walking around. He was out of the wheelchair. And then there was another surgery. He had to re-break his fibula as a part of the treatment. And then that carried into spring of 2019. And then beginning spring of 2019, he really got going and working more. They bought another tractor that he was working with, that he was working on the farm. That $800 a month payment to husband continued all the way into January of 2023 when the parties separated. And when the wife moved out of the marital residence and the divorce proceedings began. Now, if I could make one additional really important point, because I think it goes to Your Honor's question. Wife's income is still a contribution from husband. It is marital property. And so even if all of the revenue that was deposited into the Green Barns operating account was quote-unquote wife's income, it was still earned through labor during the marriage. That is, by statute, marital property, and counts as a contribution that both parties made. Thank you, Your Honors.
Thank you, counsel. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. Court will stand in recess until the call of the docket in the morning.